Hello, everyone. Thanks for being with us today for a special edition of Legally Speaking. I'm Stephanie Haney, and today we're here to talk about the latest indictment against former President Donald Trump and kind of break down this process and just demystify it. So to talk to us about this, I have former federal prosecutor Subodh Chandra. Subodh, thank you for being with us today.
Thanks for having me.
Now, this latest indictment to come in against the former president tied to the January 6th riots, the third indictment now that we've seen come out against the former president. This investigation has been going on for a long time. Is it typical for an investigation to take this much time before we see an indictment come out?
Certainly an investigation of this complexity, an investigation with this many moving pieces and parts, this many witnesses, this much impact, this historic, I would certainly expect it to take this long. Now, I think for everybody on every side of these issues, everybody wishes it was over yesterday, but it is not unusual for an investigation to take this long, that is this complicated.
Okay. Now, this is not the first federal grand jury hearing for the former president, but for a lot of people, they have no experience with the federal grand jury hearing. So can you kind of just explain what that looks like to people who have no idea what has been happening behind the scenes here?
Let's start with the basics. Our Constitution requires this right of grand jury. Our Constitution requires that for these serious felony charges, the government doesn't just get to charge you. A prosecutor doesn't just get to say, hey, we're charging you, you're guilty. Instead, we have ordinary citizens like you and me who get to participate in this process. They're randomly selected to be the grand jury. And that means there are the individuals who are going to hear the evidence and ultimately decide whether to bring an indictment. The prosecutor doesn't get to decide that alone. The prosecutor can recommend it and ask for it, but it's these ordinary citizens who are going to make the decision after hearing all of the evidence presented to them by the prosecutor and by witnesses appearing before the grand jury.
Okay. And in this instance, what is required of those citizens who are looking at this information? What do they have to do in order to return a federal indictment?
So what will happen is over the course of many months, it's apparent that those grand jurors have been hearing witnesses, have been reviewing documents where subpoenas have been sent out on their behalf by the prosecutors to gather evidence and make witnesses appear before the grand jury. And then after all of that evidence is heard, ultimately the prosecutor will either ask the grand jury to return an indictment or say to the grand jury, we are not recommending that an indictment be returned. We don't think there's insufficient evidence here. The government doesn't want to prosecute this case. At that point, the grand jurors vote in secret. The prosecutor is not present in the room for the vote. It's one of the most solemn moments in the grand jury process where the prosecutor leaves the room and the grand jury foreperson then takes a vote. And then if there are sufficient votes, if there's a majority of those grand jurors, then there is an indictment and you have an official indictment that is returned and then filed on the docket of the court, sometimes under seal for some period of time until a judge says it can be unveiled. And sometimes it's just now openly on the docket.
So that's an interesting point too. What happens behind closed doors in a grand jury hearing? We don't necessarily get to see any of that before something would go to trial. What's the reason for that?
Well, not only do we not get to see it, but the prosecutor doesn't get to see the deliberations of the grand jury when they take their vote and when they're discussing the issue ultimately on how they want to vote. You were asking what's the reason behind that? Well, the reason that grand juries are secret, the whole process is secret, and it is a one-sided presentation. It's been famously said that a prosecutor can indict a ham sandwich as a result of there being this secret process. But there are a couple policy reasons for that. First and foremost, we want to protect witnesses, right? So if it turns out that someone's been subpoenaed before a grand jury, and let's say it's a high-risk case where there could be obstruction of justice, there could be physical threats to the safety of an individual that appears before the grand jury, we want to have a secret process so those witnesses have a place that they can go and testify without being in jeopardy. Second, it is in large part to protect the reputation of the person who's being investigated. Now, obviously, we know a lot about this investigation because it's a famous case. People are paying attention, and people who have appeared before the grand jury are talking. But in your ordinary case, what would happen is that you would expect that the proceedings are taking place in secret. The individual who is a subject or target of the investigation might know because the prosecutor might alert them, but often they don't know. And then once the decision is, if a decision is made not to pursue an indictment, then at that point, there's been no harm to the public reputation of the person being investigated. That's one of the other recommendations.
Okay, and with this person, with the former president, Donald Trump, oftentimes he's coming out ahead of an indictment being announced and saying, I'm going to be indicted on this day. So can you just sort of walk us through how the former president gets informed of the fact that he is going to be indicted or has been indicted?
Well, first of all, we know that the former president says a lot of things that are not true. Media organizations have fact-checked him left and right, and there are thousands and thousands of lies and misstatements that have been documented. So we haven't always known when he has declared, I'm going to be indicted, whether that's true or not. But in this case, I think there have been reputable media organizations that have reported that Trump received what is known as a target letter, which is a letter that informs you that you are the target of a federal criminal investigation. It now makes it official. Generally speaking, when you receive a target letter, you are probably going to be indicted. You might have one last chance to try to talk the government out of it, but generally speaking, you're going to be indicted. A target letter really means, hey, we've probably got you. Now, a subject letter means that your conduct is a part of the scope of the investigation and you might become a target. You might want to cooperate with the government and talk to us and see if you can talk us out of it. So those are the different categories. In this case, it does appear that the former president was informed, either directly or probably through his counsel, his designated counsel, that he is very likely to be indicted and he is a target of this January 6th investigation.
Okay, so now that he has been indicted in the January 6th investigation, we do know that that's come out, even though he did post those things ahead of time. What comes next for the president in this instance?
Well, as we saw in the instance of the classified documents case, the national security documents case, he will appear for an arraignment because of his notoriety and reputation. He is probably going to be able to self-surrender and not be arrested or anything of the sort. Instead, he and his attorneys will arrange for him to appear at the courthouse, be booked, appear before a United States magistrate judge, possibly a U.S. district judge, and then hear the charges against him or waive the reading of the charges, plead not guilty, which is what we anticipate, and otherwise start to hear about the case process and possibly get a schedule in the case.
Now, we know that he faces New York State charges. Charges in Georgia are a potential possibility here for the former president. He does also face other federal charges tied to the classified documents that were found at Mar-a-Lago. So how will any of these cases, if at all, impact this case with the January 6th riots?
Well, that is a really interesting question, because all I can say is that if I were an attorney representing a client facing this much jeopardy in this many courthouses, I would be one fatigued lawyer. Now, in this case, it does appear that Donald Trump has multiple teams of lawyers, lots of lawyers working on his matters, but even he as one individual is going to have to focus and concentrate on his defense in at least 3 matters and possibly a fourth, with the Georgia indictment looming, and it looks like it's going to be launching sometime in August. So what is going to happen now is that somehow the lawyers for the government are going to also themselves have to coordinate with these various courts to ensure that the trial dates and the discovery deadlines are spaced out enough so that everyone has the capacity not only to disseminate and exchange discovery, but also to absorb all of that discovery and prepare for trials. It is not a small undertaking. It is a lot of work and it is a lot of jeopardy. What I expect, though, given the severity and seriousness of the matters, that these federal judges will be accommodating to the parties, to the government, to Donald Trump, and ensure that there's some reasonable spacing of the schedules in these matters and not directly conflicting schedules. But it is going to be tough.
That is a lot of different places to manage a lot of different calendars. And the former president, of course, is not the only case that these courts are dealing with. So a lot of cooks in the kitchen on this one, it seems like, for sure.
Well, and I want to mention one other thing, which is we've persistently seen the former president claim that somehow his campaign schedule should affect the court schedules, and that's just completely preposterous. The schedule, the schedule of a private citizen on matters that are purely discretionary. It's up to him as to whether he wants to run for president or not. It's up to him as to whether he wants to take a walk or not. It's up to him as to whether he wants to have lunch or not, or go dine out with a friend. The bottom line is, though, court schedules do not and should not wait for a private individual or somebody who's charged, a criminal suspect, somebody who's been indicted, saying, well, I want to go do this other thing. I mean, can't tell you the number of times that people I've either prosecuted or that I've represented have said, well, look, I just really want to go on this overseas trip to go do something, or we've always wanted to see the Acropolis. And federal judges' response to that is no. So the campaign schedule should really have no material effect on this. We might see some of the judges bend and yield a little bit to that and say, oh, well, okay, you have to be in Iowa on that day. We'll somehow accommodate you. But in my humble opinion, that would be special treatment. And Donald Trump should be treated no better and no worse than any other individual who is facing criminal jeopardy.
Well, that is certainly what we hope for in our criminal justice system, is equal treatment across the board. Absolutely. Now, in your opinion, as someone who has been a federal prosecutor, do you have any idea how long it might be before we see this case actually go to trial? We get through all the pretrial motions, all the hearings, all the scheduling, and then we actually see evidence being presented in a court?
I would expect that we will not see a trial in the January 6th matter at a minimum in 9 months, and probably closer to a year, and it could be as long as 15 months. I think that it is unlikely that any judge is going to want to extend this out more than 15 to 18 months for a hard trial date. And that is going to require a lot of work, and that's going to require a lot of ambition by lawyers on both sides, big teams reviewing large volumes of evidence. But it is unimaginable to me that it would extend out too much further than that. It is also unimaginable to me that any lawyer could realistically try this case on behalf of Donald Trump in, say, 6 months or 7 months or 8 months. That's really just not feasible, given the magnitude of what is happening and what I expect would be the volume of evidence that has to be digested.
Now, I'm going to ask you a hypothetical question here based on something that has never happened, but it is something that a lot of people have posed the possibility of. Suppose these trials extend past the election. Suppose the former president gets reelected. We're looking at a situation where he's already been put into office. It's past the inauguration for him. Is it possible, if he is convicted, for him to immediately pardon himself if he is the sitting president?
Our great nation has never faced this question before. So anyone who claims to know the answer to that question is fibbing. They don't really know the answer to that question. But what we do is we start with the plain language. We start with the plain text of the pardon power in the Constitution. And the pardon power in the Constitution is silent on the question of whether a president can pardon him or herself. It does appear to be broad and sweeping pardon power as to federal offenses, not state offenses, but federal offenses. And so some of the New York matter isn't going to be affected at all by the pardon power. So what it means is that it places all of us in a great deal of uncertainty as to whether one man who is in so much potential criminal jeopardy can then pardon himself and escape any accountability whatsoever. And a pardon, as probably many of us know, can be issued even before there's a conviction. But to accept a pardon, you essentially have to implicitly admit guilt. So he could pardon himself, implicitly admit guilt by accepting the pardon. And if that happens, we're in just uncharted territory for our country and the rule of law.
Well, we certainly hope it doesn't make it to that point. I think I can speak for everyone in the country that would be just, it'd be a real terrible situation for the United States to find itself in.
I mean, remember just how much distress the country was in over the pardon of Richard Nixon by President Ford when President Ford took over after Nixon resigned. And Ford's decision to pardon Nixon was a very controversial decision at the time. This would be that on steroids, the difference between an atomic bomb and a hydrogen bomb.
Very, very succinctly put in that matter. All right, now, if the former president, were to be offered a plea deal, what would that process look like in an instance like this?
Well, putting aside for the moment the suspension of my disbelief that the former president would ever accept a plea deal under any circumstances, but let's just engage in the hypothetical. Well, what you would see initially is there would have to be some indication, I would imagine, from the defense that they're interested in that type of discussion. That would either be defense lawyers acting on authorization from former President Trump, or that would be lawyers just trying to explore the waters so that they can explore all possibilities and discuss them with their client. At that point, I think certainly if I were the government prosecutor, I would want to know, are you serious or are you just wasting our time? And if I were satisfied that the lawyers are serious and that Trump is serious about wanting to explore those possibilities, then at that point, the prosecutors would get together and they would confer and they would try to decide what is an appropriate and fair plea deal. Now, keep in mind that the federal judges are constrained by the federal sentencing guidelines. And so there are guidelines, ranges recommended for certain types of offenses with certain types of characteristics. And so the prosecutors would want to offer a plea deal within the range of those guidelines. And people who are convicted or who plead guilty to federal offenses do get credit for something called acceptance of responsibility. You can get some levels, some reduction in the sentence associated with that. So there would be a bargaining process, but it can only go so far. And then at that point, the former president would have to decide whether he wants to take the deal or not. There could also be a circumstance in which the sentence is left completely to the discretion of the court, and Trump is allowed to argue for what's called a variance or departure, where the judge could reduce the sentence even more.
Okay. Very interesting point in time we find ourselves in today, Subodh. We appreciate your expertise in this matter as a former federal prosecutor. Thank you for being with us today.
Thank you. These are interesting times.
And thank all of you for being here with us for this special edition of Legally Speaking. As this case unfolds against the former president, we will certainly keep you updated as more information comes in. Thanks for being with us. I'm Stephanie Haney.